May it please your Honour, my name is Pancho, Pancho, initials M.E., and I appear for the defendant, Dr. Cale. Your Honour, the dispute between my client, Dr. Cale, and the plaintiff, Templeton Constructions Proprietary Limited, originates from a breach of contract by Templeton Constructions. Your Honour, if I may explain, this breach of contract began when Dr. Cale disclosed his liking for the colour in which the honey ash wood displayed, before the contract between himself and Templeton Constructions was made. Your Honour, it is reasonable to state that the reason for Dr. Cale's choice in the honey ash wood was because of the colour and because he verbally disclosed this to Templeton Constructions. It is reasonable for them to have ordered this type of wood for Dr. Cale's flooring. This is evident by the act of ordering the honey ash wood from the wood supplier. It is also reasonable to state that by accepting Dr. Cale's direction, that Templeton Constructions should have made certain that the honey ash wood ordered from the supplier matched the personal preference of Dr. Cale's disclosure. The case of Ruxley Electronics versus Forsyth is a good example of the reasonableness of a client's personal preference. The facts of the case are as follows. Mr. Forsyth, the landowner, had specified for the construction of a swimming pool at his home, and which was not provided precisely according to the specification. Mr. Forsyth pointed out to the contractor that being a fairly big man, he would feel anxious about diving into a pool, according to the original specification, was only 6.6 inches deep. Mr. Forsyth wanted to have a depth of 7.6 inches, and the contractor agreed to amend the specification accordingly. However, the end result was different, and the pool maximum depth was only 6.9 inches deep. Your Honour, the verbal disclosure that my client stated to Templeton Constructions was also a direction said to instruct the go-ahead with using the honey ash wood for the flooring. Section 67I.1 of the Queensland Building and Constructions Commissions Act 1991 states that the section applies if under a building contract, the contracting party for the contract or another person authorised under the contract may, without the agreement of the contracted party for the contract, give direction to the contracted party. In point 5 of the same section provides a definition of the term direction, which includes the following: agreement, approval, authorization, certificate, decision, demand, determination, explanation, instruction, notice, order, permission, rejection, request, or requirement. Your Honour, if I may also add that according to Section 8 of the Domestic Building Contracts Act 1995, which states that the implied warranties about the work to be carried out under a domestic building contract are part of every domestic builder's contract. Point F particularly states the purpose for which the work is required or the result which the building owner wishes the work to achieve, so as to show that the building owner relies on the builder's skill and judgment. The builder warrants that the work and any materials used in carrying out the work will be reasonably fit for that purpose, or will be of such a nature and quality that they might reasonably be expected to achieve that result. When my client, Dr. Cale, disclosed his personal preference to Templeton Constructions about the colour of the honey ash wood, Dr. Cale wanted to achieve a certain result by the completion of the renovation of the flooring in his home. However, due to the colour variation between what he had initially disclosed to what had been fitted for his flooring in the first zone, Templeton Constructions has committed an offence under Section 8F of the Domestic Building Contracts Act 1995 by not using better judgment and warranting that the colour of the honey ash wood ordered from the supplier would be an exact match to what Dr. Cale disclosed. Your Honour, it is clear that Templeton Constructions has breached the contract between them and my client, Dr. Cale. My final argument to be put forward, and one that holds the utmost importance, is that the disclosure Dr. Cale verbally stated before the contract was made is an express term. An express term, as we know already, can be either orally or in writing. This term is a condition of the contract as it so directly affects the substance of the contract. This is because my client agreed to contract with Templeton Constructions due to the assumption that he would have received the correct colour for the type of wood he chose. The non-performance of not checking the colour match of the honey ash wood which was used is a substantial failure to perform the contract at all. Therefore, my client, Dr. Cale, has the right to terminate the contract, as illustrated in the case of Arcos versus Renovations. The facts of the case are as follows. The case involved a contract for the sale of timber, which the buyers intended to use for the manufacture of barrels. The timber delivered by the sellers was only fractionally different from its contract specifications and was still suitable for its intended purpose. The House of Lords affirmed the right of the buyers to terminate the contract. This is further supported by Section 16 of the Sale of Goods Act 1896. Which states the following: when there is a contract for the sale of goods by description, there is an implied condition that the goods shall correspond with the description, and if the sale is by sample as well as by description, it is not sufficient that the bulk of the goods corresponds with the sample if the goods do not also correspond with the description. Your Honour, my client, Dr. Cale, has no need to repudiate the contract between himself and Templeton Constructions, as the breach of the above condition gives my client the right to terminate the contract. However, my client wishes to cross-claim the amount of $20,000 for the current work being done on the flooring of his home.